We are going to talk about real estate, probate, and family law. And believe it or not, all of these three topics actually are connected in one way or another. So, like I said, I practice family law here. We have three other very distinguished panelists, and I will let them introduce themselves, starting with Janine.
Why did I have to go first? Hi, my name is Janine, and I am a local realtor in the Central Florida market. We specialize in new construction, resale, selling of your home. So whatever real estate needs or question you have, I'm your girl. We're available. We can help you. So
awesome. Jabir.
Hi, everyone. Jabir Najir. I'm with Rajan mortgage broker. Actually service the Florida and the Georgia markets, and pretty much take care of everything. Work very closely with Janine, actually for quite some time. So help everybody when it comes to the purchasing of their first home or investment property, or when it comes to refinancing. I am the person you want to speak to. I also help with a lot of challenging deals whenever you don't meet the cookie cutter, guidelines of the bank. So I'm the person to speak to.
All right, awesome. Thank you for joining us. And Kamara.
Hello, everyone. My name is Attorney Kamara Williams. I actually practice and specialize in probate, guardianship, and estate planning. And when you get done dealing with Janine or Jabir, when you get your home or investment property, I would be the one you would talk to about actually how to maintain or keep your assets. Also, we're going to probably get into what probate is. So how to actually keep your assets to pass down to your descendants or your heirs. So I'd be the guy you want to speak about, Smith & Williams Trial Group.
Let's just talk about probate. So Kamara, can you explain just generally what probate is for those who may not know or understand?
Yeah, so probate is a fancy way that the courts say distribution. And the easiest way I can say it is that the courts need a vehicle in order to decide who gets what in your estate. So when you die, most of us are going to go through probate. There are ways to get out of probate, but for the most part, it's just a way for us to kind of just describe who gets what and where and why, and protection of creditors, protection of heirs, and protection of everybody from the person who's no longer here.
So Janine, let me ask you this. Have you dealt with someone who was trying to sell a property that is in probate? And can you explain what that experience was like?
Yeah, to be honest with you, Conti, especially in our community, a lot of people don't even know probate exists. They don't even know what it is. So typically you'll have a family member that has passed on, and one of the heirs or whomever it is reaching out to us to sell the property. Little do they know they don't technically have any rights to sell the property at that time, because technically the property still belongs to the deceased. And that's where we would advise them to seek and have a discussion with a probate attorney. What I'm finding is in our community, a lot of our people are not ready. I'm dealing with one right now that the son didn't even have enough money to hire an attorney. So yes, he's on the well. The father have left this property to him. However, we still have to go through probate in order for him to be able to sell it legally. So that's what we're seeing is, our community not fully understanding what probate is, what is the requirement or how much is going to cost them to be able to sell the property. Sometimes they're not even in the same state where the property is located. So that's why I'm really happy we're doing this session today.
Okay, awesome. So Jabir, let's talk about mortgages. How are mortgages impacted, or trying to sell a home or purchase a property that's in probate? Like, what does it take longer? Can you kind of give the viewers an idea of what that looks like?
Yeah, sure. I appreciate it, Conti. So like Janine just mentioned, a lot of times we don't have any idea that probate exists, or sometimes if you've been living in the home with a family member, whether it's your parents, grandparents, or just somebody that you've been taking care of for years, a lot of times they just say, hey, the family knows that I'm supposed to get the home, and they decide that they're going to finance the home, sell the home, refinance to take cash out. We run into that quite a bit. And I've definitely had clients in the past come to me to refinance a home that they thought was theirs, because that's just what everybody knew the home was supposed to go to them. and we go through the process only to find out that the home hasn't gone through probate. So now we start the process of probate, which anybody that's gone through probate, they know it could take quite some time. It's not a quick process. Even if everybody agrees on the way it should go, you still have to go through the legal process. So we could always pre-approve, you get everything in order, but we kind of just sit on our hands until you go through the probate process, because there's nothing that we could legally do to finance that property in your name. So, you know, one of the biggest suggestions I have, and I'm sure that that's where Kamar comes in, is basically planning ahead of time for those situations, especially if you know that family member may be becoming older or if they are falling ill, to prepare for that time.
Yeah.
So that's a good point. So Kamar, can you explain the probate process? Like what, so if someone's trying to sell a property, someone passes away and someone owns, and their, you know, their parents or someone, you know, had a home, and and someone comes and say, hey, you know, I need to sell this home. What's the process like with initiating and starting probate?
All right, so that's like 3 separate questions. So I'll start off with a probate. The process starting a probate, it can be a bit tedious because you know, you're going to need initially, you're going to need the death certificate, and you're going to need the proof that the funeral has been paid for, or whoever the service, because that is the first creditor according to the state, and that's in state law. So I can't even open up the probate without those 2 things. Then we're going to have to start a petition. And depending on what type of probate we have, there's a formal or a summary. Florida has designed that a formal is based on a certain amount in your probate, a certain amount in your estate, and a summary administration is based on something less than $70,000 within your $75,000 in your estate. Now, if it's a summary administration, that's great, because you can actually get the probate process, what we say, within 3, at the most 9 months. The earliest I've done is in 3 months, at the most 9 months. If it's a formal administration, it takes a lot more, because then you're going to have to do a notice of creditors. You're going to have to do a waiver throughout for all the heirs. You're going to have to do all these things, because they're saying it's a lot more complicated of an estate. Those things can take anywhere between 6 months all the way up to, you know, a year and a half, if we can't get everything corralled in the same space. So I understand what, you know, Jabir is saying, that when you hear clients say, oh, why is this probate still open? I'm like, I'm not trying to keep the case open. This is not me. It's a lot of cattle to herd within a particular estate. And so, you know, there's a lot of things like, you know, there might be creditors that have to be paid, right? Or we have to negotiate down to creditors, because the estate's never going to close, especially when they make a claim on it. The estate's never going to close unless the creditor has been satisfied. So Florida's not going to let you get away with that. And once the creditors have been satisfied, all of them, and there's a written waiver of their interest, then you have to get the heirs to agree to the inventory within the estates. Then we have to go through all the inventory. Then after the inventory, I know I'm being very technical here. I'm sorry.
That's good.
That's fine.
And then after the inventory, then we have to get a certification of waivers from all the heirs saying that they agree to the distribution. Oh, by the way, we have to go contact the state of Florida and let them know that there's no Florida estate tax on the estate, and there's no the state of Florida in general does not have a claim against them, and we have to wait 30 days after notifying them, because they had up to 30 days. That's at the end of everything. So, you know, it's a lot to do, and it's a lot of moving parts. And I don't mind when people try to do the probate themselves, but there's a reason why you have to get a probate attorney, because there's a lot I'm going to have to do institutionalized. And oh, by the way, certain counties, there's 6-7 counties. Broward has a different checklist of requirements than Dade County, or definitely different than Hillsborough and Orange. And I'm thinking about all these counties that we have all these probate cases, and in North Florida we have some cases there. So, you know, depending on where the person passed away, their residency, you know, I could be dealing with something entirely different about what the requirements are in order to close out the estate. And it could be depending on the judge too, because a certain judge may say, I want this, as opposed to the, you know, so it's just a number of different things. I can talk about probate all day, and I'm not trying to take up this video chat. You know.
So no, that's helpful. So people may be asking, well, how does probate tie in with family law? And so I had a case where and people, I hear this all the time, with young people, I don't need a will, I don't have anything. But what people don't realize is that you don't know what you're going to be worth at the time of your death. And so what happened was that there was a case where a young man was like 19 or 20, and he passed away tragically in a car accident. And so the mother started probate because there was a settlement that was going to come about as a result of his death that was going to be paid out by the insurance company. And the father never paid child support. Never paid child support. He owed over $100,000 in back child support. And the hardest thing that I had to do as a family law attorney is to explain to the mother that the father was going to get half of that settlement, less the child support that he owed, but that he was going to get half of that settlement because he's the father and there was no will from the son saying that the mother or whoever else would, get whatever, would get his assets at the time of death. And so, when people say, I don't own anything, I don't need a will. Yes, you do. Right. Because in that case, that was really one of the hardest things I had to do was explain to her, that's the law. He's an heir. The father's an heir, and that you'll get the money for the child support will get paid out. Right. But he's still going to get the rest of the money. So probate and family law and real estate can all kind of, work together. And in that case, that was just a really hard conversation to have.
I just want to make sure we're clear here. You having a will, because that is often a misnomer in probate, does not, it helps, but it doesn't protect you.
Absolutely.
But, and so you can have this will.
Yeah.
But, because all a will is just a designation of of the deceased interest. And so, but the court be like, oh, okay, I'm going to take that into strong consideration. If there's case law backing it up, I take it into strong consideration. But if the administration of the estate far outweighs the reasonableness of the distribution within the will, the court is going to go that way. So let's say somebody in their will saying, I want all my estate to go to my son, and it's $100,000, but I owe this creditor $300,000. Well, the son's going to be like, well, I'm owed $100,000. And the court's like, yeah, I get it. But, the administration of this estate takes precedence over, the interest of the deceased, and definitely over the interest of the beneficiaries, right? Or heirs, rather. And so there are ways to protect against that, but we have to be really very clear, and especially within the Black community, of understanding that, yes, you do need a will, 1,000%. Attorney Smith is 150% correct about that. It doesn't matter how small your estate is. You need a will, but you also need some other things for asset protection. So I'm sorry to jump on.
No. I would agree with you, because Jabir and I have been working on one for an entire year. And having the son has a will, and he has the rights to the property, but explaining to him that we have to go through the, probate process before he can legally sell the home was very challenging at the beginning. And in addition to that, he didn't really have the funds to hire an attorney. So that has caused so many delays for that particular property. Now, the great thing is we're in a very healthy market. So his property actually, we've an increase in value. However, if it was any other market where, properties was decreasing in value, it would really impact him and his family. So I completely agree with Kamar. It's a will is important, but there's other things that we have to do to make sure that, if something like this happens to a family member, we're ready to go.
All right.
And just to clarify for everyone, and myself as well, Kamar, are you saying that, say that somebody, when you say creditor, say somebody has medical bills, credit card bills, and you have $100,000 at the time of your passing, even if you have a will, are you saying that they actually take care of those creditors first, and then whatever is left over, the rest of the family receives?
Absolutely. First party creditors are first. It's I don't know why the legislature decided this, but it's the funeral home. I guess they say they got to get paid first. you know. So shout out to the funeral home lobbyists who helped knock that out. And then you have hospital bills. That's the second party, and then you have credit card, and I think loans, meaning banks. They fall within that tier of after hospital bills, right? And so everybody needs to get paid before the heirs get paid, and it's weird, but normal people don't have lobbyists, but these people do. These companies and special interest groups do, and therefore they got the legislature to designate we need to be on the tier of responsibility when closing out a probate. Okay. And you need an attorney to kind of tell you which tier you're in, and if there's ways to negotiate it, but that comes with an attorney having experience to do that.
So if we could talk about briefly, and we'll do another live about this in general, but how can you protect yourself from, having your property or getting into the situation? Like, what can you do, Kamara, to protect yourself?
Yeah, I always recommend, and I'm not only a client, I'm a president of this. I have a trust, and that's the way you protect yourself, is by putting in trust. I always explain to people that a trust is like a lockbox, right? And once you put things within that lockbox, it protects you from creditors, right? And you get all the benefits. It's like friends with benefits, right? And so you get all the benefits of having your estate, and you get none of the responsibilities, right? And so that's the best way I like to put it to people. And so I recommend everybody get trust. And there's literally hundreds of types of trust. So a lot of times when people hear a trust, they're like, oh, I don't have a lot of money. I only have this one little home. And I have, I'm not going to get into it because I'll soak up all the time. But I have a story that I like to tell when I give these seminars about how it doesn't matter how small your estate is. It just matters that you have an estate. And so I'll leave it at that. But yeah, that's the way you protect your interest, is creating a trust and putting your properties and your interest and all that within the trust. I have one. My wife has one that I created. That's how important it is. So we have two separate trusts, right? And then I have a family one, and so I'm a big advocate of it.
No, that makes sense. So one of the things that I have been getting, unfortunately, a lot of calls about, Kamara, is that there's a parent that has died as a result of COVID, especially in like the past year and a half, and the father never established his rights. He never established paternity officially. He may have just signed the birth certificate, but didn't have any court-ordered time sharing. Yeah. And then there's an issue with, the mother's parents, don't want the father to get the kid, and we're having to fight, and file a lot of different custody cases or cases to establish paternity and to get time sharing going because of COVID and the loss of a parent. So what can people do to, and I can talk about it from the family side of it, but if you could talk about, if you want to make plans for your children, if something were to happen to you, how can they do that and what can they do? And I can talk about how it works in the family law side of it.
Well, you could actually, within your will, create a guardianship provision, right? And in that guardianship provision, it outlines what you're trying to do and designates to your child. We're not going to get into this direction here, but our firm handles, and it's all under the same probate court, guardianships that are important within our community as far as that very same thing. Maybe not for child support, but I'll give you one instance. Attorney Smith, we're friends. I keep wanting to call you first name.
You're fine.
So there was an instance that we're actually dealing with now where they weren't together, but they've been together for years and they got shared kids, right? That situation. And the woman ended up passing away because of COVID, and she has money in the bank and she has children. And the boyfriend / baby father wants to get a hold of those funds. She had a good job, real good job. Wants to get a hold of those funds in order to, help with the children. Unfortunately, he can't get access to that because he's not married. And even if you're married, you may not even be on the accounts. That's another thing. But, that's another issue. But let's just address the fact that he's not on the account. So now we have to do what's called a guardianship over the funds, get a court to order the distribution and put them in a registry in order for the distribution for the kids. And all that could have been avoided, had you decided to get a will and have a provision. But now you're going to pay me thousands of dollars to handle this particular issue. And so, it's just little things that we can do to avoid the hell that we leave in after our life has decided to pass.
No, I agree. And so what's happening now is that, just to be clear, just because you sign the birth certificate and if your name's on it, that does not give you rights as far as time sharing is concerned. The statute states that the mother is a default custodian of the child or the children until there's another order that states otherwise, right? So what we're having to do is, in the cases where the grandparents or the other family members of the mother that passed away, we're having to go and file a petition for paternity to establish the father's rights in order to get him custody or time sharing with his kids or his, the child. And so it's another whole process. And so, I mean, it's always good to have your documents in order, even if it's a court order for your time sharing. So then that way we don't have to start from the very beginning, make sure you do a DNA test and, and to go through all of that ahead of time. But some people just get, comfortable and they don't want to handle the business of getting your estate plan done or getting your, your time sharing order in place. And it makes it more difficult because we can't just file an emergency motion and say, hey, the child has to go with dad. We have to establish that you are in fact the father first, if the mother's not here to admit that you are the father. And so we have unfortunately received a lot of phone calls where, the family, and on the flip side of it too, you have some families where the mother was, the primary caregiver for the kids. The father was not involved at all. And then all of a sudden, since one parent passed away, that other parent wants to be able to, get access to some money they believe is there or whatever. And now they want to come and get sole custody of the kids, and the kids don't even know that person's name. And so we're seeing this a lot in family law, where we're, trying to help families on both sides figure out what, what their rights are and, and to help them navigate through COVID and losing one of the parents. So have you experienced any of that, Kamara, at all with people upset about time sharing or figuring out what to do?
Not necessarily with the time sharing, but, really just on the basis on my end, again, it's just about assets, and so that's kind of where this is why you're good at what you're doing, because I don't have the capacity when people start getting to the meat and potatoes of like the time sharing and, you're right. I have dealt with the kids don't even know who this, person is. And all of a sudden now they're trying to insert themselves in the person in their child's life by way of, for again, my set outside of it, guardianship. I would just say that when people are dealing with their individual who they've had children with, shared children, there's only so much you can do regarding not having a relationship with them. But there's always a time when the bell's going to come due, and for me, it makes sense for you to always continue that open line of communication, because what you're avoiding now is going to happen. God forbid if you should pass away and your stuff is not tied up. So I don't know how to without getting messy.
I have a quick question in regards to that. So what happens in the case that somebody passes away, and this is, I guess, a combination between a question for Kamara and Conti, and say that they have children and they weren't married, and then they have assets that are distributed amongst family members. Who actually manages the assets for the children if they're underage? Is like one family member in charge of that, or
if we have what's called a permanent guardianship and a temporary guardianship, and managing the assets would go into a registry unless you can set up a separate account that the court has you submitted to the court, and you can keep a running inventory. But for the most part, we would ask for initially a temporary guardianship, emergency temporary guardianship, so you can actually have access, and then we ask for a permanent guardianship that takes a little bit more work or whatnot. But yes, so that's how, I don't know if that answered your question, Jabir.
Yeah, it does. Yeah.
Okay.
No, that makes sense. And another way that family law and probate are, or not necessarily probate, but death works, is that when people get divorced, I've had this happen, I think 2 times, where when people get divorced, they forget to update the beneficiaries on their policies, on their 401k. And then what happens is that, the once the spouse passes away, and then the ex receives what they were listed as a beneficiary as. And so when people are getting divorced, it's really important that you don't know, tomorrow's not promised. You need to make it a priority to update your beneficiaries and to make sure that when you pass away, the people who you intend to get those assets will actually get them. And so people have come to you, Kamara, like, well, that they're divorced, and you're like, well, or this is common too. The house is in so and so's name and they never got the deed fixed, right? Yeah. So now it's time to get rid of the house. Well, they divorced. He was supposed to have it, but the paperwork doesn't match what's supposed to happen. Yeah. And so when they come to attorneys or they come to professionals like Jabir and Janine or Kamara and myself, we're like, our hands are tied. We can't really do much because, that's, if you didn't take the time to update your beneficiaries or to, change up the information, it is what it is. Yes, the person may be divorced, but they're still listed as a beneficiary in the 401k. Yep.
I'm laughing, not at you. I'm laughing because it happens so much that we are literally dealing with a case like that. And I'm trying to figure out how to say this because somebody might be listening that, they'd be like, that's my case. I'm like, I promise you it's not your case. Where somebody literally they got remarried and the life insurance policy was with the ex-wife, but they never updated that. And then a person ended up dying. And so the new wife, who's been in this person's life for a certain amount of time, it's expecting a certain type of payout. And, the insurance company is like, well, no, this goes to the first Mrs. So-and-so.
Yeah.
And, now there's a contention about, who gets what. And I will tell you the easy answer is to say this, is that the courts, unless it's a lot of different, circumstances, but the courts will give it to the first wife because that contract holds. You're making a contract. When you sign an insurance policy, it's a contract. And they're not going to go against the nature of the contract, no matter how long it's been since you're no longer with that spouse. So I update my my insurance policy every 2 years, even though the fact that I'm just celebrating 10 years of marriage. But congrats. Yeah, thank you. And so, but I update it every 24 months. I know I always go over them to make sure, even though nothing's changed in my life, right? Because it's a good habit to have, and I implore people to do that. But yeah, I try to be as basic in this explanation because I'm dealing with a few cases, and somebody might be like, "Stop talking about me on this live," and I'm like, "I'm not talking about you." But.
Well, no, we appreciate everyone's time, and I think it would be very helpful to get Kamara back on and talk about estate planning and kind of about the different vehicles and things you can use to protect yourself and your assets. But before we go, I want to make sure that everyone knows to tune in next week. We're going to have a CPA to talk about family law, taxes, real estate. So please tune in next week. Jabir, how can people reach you if they want to reach you?
You can always reach me by email, which is Jabir, Jabir @riajan.com. That's RIAJAN.com. Or you can contact me.
Did we lose Jabir?
No.
Okay.
Can you hear me?
No, he's still on.
So we have Jabir here at the bottom. The phone number, and we have his email at the bottom, or his Instagram, right?
Yes.
Yeah, that's his IG.
That's all my information there.
All right, cool. And Janine, how can people reach you?
Same, usually by phone. My number's, there it is, 407-595-8634. Or on IG, we try to give as much information to educate our community as much as possible. Conti, what you're doing is so amazing because you don't understand how much we don't know about this whole process. So definitely on IG, follow us for some tips and real estate related information.
Awesome. And Kamara, how can people reach you?
Yes, you can reach me at on my email at cwilliams. Oh, yeah, or my email is cwilliams@swtglaw.com, or the phone number at 888-798-4529 or 888 SWTG Law. So it was a pleasure, and I agree that Conti, what you're doing is an amazing thing, and I applaud you and applaud everybody on this chat. I'm just happy to be a part of it.
Well, no, thank you all for joining. If you want to reach us, you can. We can find us on social media at Conti More Law. You can call us at 407-831-0203. We give free consultations for 15 minutes. Everybody, thank you for joining. Thank you for being a resource. And let's continue to keep this going and tune in next week. Have a great day, everybody.
Bye, guys.
Bye.